Well, good afternoon, and thank you for joining us for today's Manulife Business Success Series webinar on employment law and what you need to know. My name is Ian McLean, and I'm the President and CEO of the Greater Kitchener-Waterloo Chamber of Commerce. Before we get started, I would like to take a moment to acknowledge that we do live and work on the traditional territory of the Neutral, Anishinaabe, and Haudenosaunee peoples, as we seek a renewed relationship based on the foundation of mutual understanding and respect. Today's session, as with all things at the Chamber, would not be possible without the continued support of our sponsors. So a special thank you to our title sponsor for the Business Success Series, Manulife, our platinum sponsor for the series, the Immigration Partnership of Waterloo Region, and this month's presenting sponsor, BDC. Of course, BDC is Canada's only bank devoted exclusively to entrepreneurs. These organizations are committed to supporting our local economy and providing businesses with the resources and tools they need to thrive. I would now like to welcome Scott Burrell, Senior Account Executive, Group Benefits with Manulife, to say a few words. Scott.
Thanks, Ian. Hello, everyone. On behalf of Manulife, I would like to thank you for joining us today. We are very excited to be the title sponsor of the Business Success Series, offering our community a fulsome learning experience by industry leaders from a diverse set of topics. Today's topic is a timely one and something I'm sure we're all interested in as we make the necessary steps to go forward and to resume business and support our clients. As a Manulife Group Benefits rep, I look after small business group plans from 2 to 50 employees. So I look forward to hearing what Chris has to say today on how COVID-19 has affected the challenges facing the small business owner. So thanks again for being here today, and enjoy the session.
Well, thank you, Scott. We are thrilled to have Manulife on board. You've been great partners of ours on a wide variety of things, but particularly for this series as we work to support all of our members, small and medium size in particular, and the local business community at large during these difficult times. Just before the session starts, I'd like to go over just a few quick reminders. Please ensure that your microphone is muted throughout the presentation so we can avoid any background noise. If you have any questions that come up through the session, you can type them into the question box in your control panel at any time. If you have any tech-related issues, a representative of our team will get back to you in just a few moments. If they are for today's presenter, your questions, they will be gathered throughout the session, and our speaker will do their best to answer as many questions as possible following the presentation. I'll be facilitating that throughout the event as we go. All attendees will be sent a recording of today's presentation, and it will also be made available on the Greater KW Chamber website. Right now, I'd like to introduce Brian Panambalin. He is the Senior Account Executive with BDC to introduce today's speaker. Brian.
Thanks, Ian. BDC is proud to be this month's presenting sponsor of the Business Success Series. I've got the privilege today to introduce today's speaker. Christopher Andre is a partner at Gowling WLG's Waterloo Region office and past co-leader of the firm's International Employment, Labor, and Equalities Group. Chris helps his clients manage their people and achieve their business goals. He brings his clients over 20 years of knowledge and experience, combined with creativity and a focus on practical solutions. Chris works alongside his clients as a trusted advisor, focused on minimizing risks and maximizing opportunities. His clients include owner-managed businesses and multinational organizations. Chris focuses his practice in the area of employment law and human rights, and represents employers in all aspects of their relationships with their employees. Chris is ranked by his peers in the Canadian Legal Lexpert Directory and Best Lawyers in Canada for his expertise in the area of employment law. Chris will be joined by Ian McLean as he facilitates this afternoon's discussion. Thank you to you both. I will now pass it back to you, Ian. Thanks.
Well, thank you, Brian, and appreciate BDC being our sponsor for this month of October, especially since it's Small Business Month, and the work that you do with with us and many small businesses across the region and across the country, actually. Before we get started, I've got some questions that for Chris, but I thought I'd maybe do a little bit of setting the stage. I think it was maybe a bit more than a year ago, Chris. We had you at one of our MBS Network Breakfast Series events, and we covered a number of the things that were happening in the landscape of employee relations and a variety of things. The world has certainly changed since the last time you were with us. One thing for our attendees, I think is important. What we're going to focus on today is COVID and some of the things that are happening right now that businesses need to know, but not on the programs themselves. I'm on a regular call. I know, Chris, some of your colleagues with the federal and provincial government on an ongoing basis to talk about the programs such as the wage subsidy program, the rent relief program, the bank loan program, and there'll be some of that will be woven through. But those things are changing and they're happening in real time. So it would be, we don't think we'd be particularly useful talking about those things right now. As those come into focus, we'd love to have you back to hear what your view is on as those things emerge in the coming weeks and months. But I think it's important that there's a lot of other things that get affected and have been affected by COVID and the changes in how we run our business, the responsibilities that business have, and the challenges that they have. So I think we want to focus a little bit on that, and maybe to start off, maybe in that context of since the last time we were together, what have been some of the recent developments in your area of practice that employers need to know? Because I think at the broadest sense, there's a lot that has changed, not just the pandemic.
Yeah, thanks, Ian, and thank you to the Chamber, thank you to Manulife, thank you to BDC for inviting me. Happy to be here and try and talk. The last, well, it was more than the middle of March. For many businesses, of course, the real focus landed on in the middle of March, but for our practice, we were seeing this coming sort of in January, February. As supplier relationships were being disrupted, particularly those into China, and so this has been on my my mind and pretty much dominating my practice for the last 7 or 8 months. What I wanted to do at the start was just to sort of update on a few little things, some call them quick hitters, whatever you want to refer to, so that we can then, as we go along, focus in a little bit more on the COVID-19 issues. So. What I wanted to talk about is just mention a few things. First of all, I suspect that all the small businesses know this. What better in the middle of a pandemic than to have a minimum wage increase? But there was a minimum wage increase effective October 1 to $14.25, and so I wanted to remind everybody of that. Second, and specific to the comments that you made during your introduction and the efforts at reconciliation. The federal government has introduced legislation for a National Day of Truth and Reconciliation, which would fall on September the 30th. This past week, it was Orange Shirt Day. Some of you may have been aware or celebrated it, but it's been proposed by the federal government for most of the businesses that are involved in this presentation. It is not necessarily going to be a statutory holiday or a public holiday. Each of the provinces would have to adopt that. And so we may end up in the end with inconsistencies across the countries. The most obvious example of that is Remembrance Day, where in certain provinces it is a statutory holiday or public holiday, in other provinces it is not. That's really up to the provincial government. For those businesses that are federally regulated, so the banks and radio stations, etc., on this call, they, if passed, that they would be public holidays, but for those that are provincially regulated, which is probably more than 90% of the folks on this call, it's yet to be determined. Another thing that I wanted to mention and specifically related to COVID is last week, among other things, there was an active health screening requirements which were passed by the provincial government. And what that, it sounded, I think, bigger than it was. But really what it meant was no longer could employers simply use a passive method of confirming that the people who are coming to work each day have been appropriately screened to avoid coming to work with COVID-19 or symptoms consistent with COVID-19. So some businesses were simply operating on the sign on the front door that said, reminder, don't come in if you have these symptoms. What the government has instituted is specific legislation that requires active screening. So those employees, I mean, effectively what has to happen is the operator of the business needs to proactively get confirmation from the employees and other essential visitors that are coming on site that they do not have any of the relevant symptoms. There's a questionnaire on the government website. Many employers are using a broader list of questions, but effectively what has changed is you must proactively get that confirmation. So for me, I happen to be in my office today. And so what we're doing currently is I send an email to my office manager every morning to say, my answer is no to all of the relevant questions down the list that you have given to me. If any of those were yes, I would not come into the office and I would, presumably go try and get an appointment for testing, and that's a different issue.
So some of those things are already in place, either by the business having set up their own processes beforehand, or as an example, when I go and see my parents at Luther Village, there's a book at the front, you have to sign in. Have you been out of the country? Do you have a fever? Are you feeling unwell? And you have to answer that questionnaire. I mean, it's that level of, you have to be more proactive and make sure it's done, not assume that the individual employee or visitor is going to let you know if they're feeling unwell.
Yeah, the operator is supposed to have a record of who has come in and has been screened. And that is for the contact tracing should a case arise. And so that's the sort of step, because things were getting a little lax, and of course we're in this, the second wave or the surge or whatever you want to call it. And so it's a proactive effort to limit those rather than simply walking by a sign and not actually being screened. Other things that I wanted to mention is the number of allowed in gatherings has been reduced to 10 indoors and 25 outdoors. That does not apply to workplaces where the stage 3 precautions are being taken, so the social distancing, the masking, etc. Speaking of masks, last week there's a mandatory mask in indoor settings, including workplaces. Now there's a list of exceptions as to when you are required and not required to wear a mask. I mean, the simplest way to think of it is in common areas, or if you cannot maintain social distancing, you must be wearing a mask. For example, I'm in my office, so I don't have to wear a mask. But when I go to the hallway to get my coffee, or when I go down the hall to use the washroom, I need to be masked in case I pass someone who is traveling, although I can tell you there's very few people to pass in my office. Other sort of quick pieces of information, the SERB program.
Can I just ask you one question around the one question around the masks? So that was the province sort of, because we've had that regional bylaw in place for 5 months, which puts the responsibility on the individual, and frankly has been working very, very well. There's very, very few circumstances where people are not wearing masks in a public setting when they can't social distance, etc. So that's been in place for us. There have been other places in the province that haven't had that. How do those two things fit together? Because I think we're under the assumption that it's everyone's responsibility, which is the way the region presented it, is it's the individual's responsibility. Not sure what the provinces look like, what their mandate looks like. But here in the region of Waterloo, for those that are listening of our members, we've been sort of living that for 5 months. Any kind of nuance there that we should be aware of?
No, I don't think that there's anything that people need to dramatically change in their plan. They should be looking at the provincial plan, because obviously that will take precedence over the local plan. There may be people on this call who are operating in different locations as well. So now we've got some consistency across, because certainly those that had operations in Toronto were dealing with a different set of rules, and various municipalities were having different rules. So it's an attempt, I think, to make things consistent across the province and have a baseline level of compliance. And so hopefully no one is going to be too far inconvenienced. And now there's a little more direction, I think, around what the exceptions are. There's a list of exceptions. So obviously medical reasons being one of them. In terms of other quick pieces of information, the CEWS program, or CEWS, however you want to pronounce it, has been extended to October 24th in its current format. The government talked about changing the format several months ago, and what has happened is it doesn't appear as though they've been able to sort of figure out how it is they're going to do that, and so they just keep re-upping the old plan until they get a new plan. You would know better than I what the timing on that is.
I was told this morning at 11 o'clock it's imminent, but imminent in some cases could be a matter of weeks or months. So, but I do think that they're moving fast, and they expect. I was just on a call 11 o'clock today that said that they're imminent was the word they kept using, which I think means in the next week or two, which would be fast and imminent by federal government standards. So.
Okay. The other thing that I want to touch on, but I don't want to dwell on, and that's because one of the stories I tell is I've been living this for 7 or 8 months, and for the first 25 years of my career, I knew scarcely little about the EI program, because no one would ask me, no one cared to hear what I had to say. They would call the government, Service Canada, whoever it was, and they would get the information they needed, and on they went. And the last 7 months, it seems like I've done little else but talk about EI and SERB and the like. I'm not going to sort of go through the details of those programs and how the transition is going, in part because it's still in its process and is remaining to be a little unclear. But what I can tell everyone, the SERB program has ended. It's now EI. There are various other support programs, and you listed several of them in your bulletin yesterday in terms of sick leave and other things. From an employer perspective, it's a compliance issue. My own, I guess what I would say from my perspective is it's not my focus, and my own view is it ought not to be the focus of employers. Employers should be sensitive to the issues and not seek to undermine any employee's ability to receive those benefits. But from my perspective, again, my own opinion, we're all going to have to pay for this, the cost of these programs eventually. And those that are entitled should receive. Those that are looking to take advantage ought not to receive. And the best information that you can get on those programs is the Service Canada website. That's where you should go to get those programs. I would be a little anxious in talking to any of the Service Canada reps, with all due respect. They have not enough training most of the time, and the website seems to be the sort of determining factor, because I know some of my clients have called and the person is basically reading from the website. So I think that that's the best source of the information. What I can tell you is, for those employees that were on SERB, they will automatically be transitioned if they were getting SERB through Service Canada. If they were getting SERB through CRA, they have to apply. How you ended up on CRA versus EI, check the website. That is not a question that I know the answer to. I can tell you that the benefits have been expanded, made easier to achieve. So the unemployment rate is fixed at 13.1%. For those who follow it, the actual rate was 10.2% in August. I don't know whether the results will be for September will be released on Friday. I don't know whether that number is going to go up or down. You might have a better sense of that, but it's likely going up because we seem to be in a surge, and businesses are more likely closing than expanding. The minimum hours have been lowered to 120 from 300. So that means 3 40-hour weeks will get, in the last year, will get you EI benefits. So it's not a high threshold. And the minimum number of weeks has been extended to 26. So it's a fairly lengthy runway for folks. And the benefits are set at $500 a week. The regular EI, so that everyone is not confused, the regular EI still exists, which has a higher level of benefit, up to, I think it's $578 or something like that per week. But anyway, I keep talking about it, but I want to encourage people to go to the website rather than look to others for answers. The SERB, which is primarily for those that cannot qualify for EI, so self-employed folks would obviously be a big group within that. Again, check the website. Another thing I wanted to touch on, again, COVID related, is advising, or maybe I can turn it back to you at this point.
Well, I would just on the programs, because I think there's lots of others, and then we're going to get to some of the other pieces, which would be, I think, just day to day, how do I interact with my workforce in this new environment? But one of the things that I think is, to reinforce your point, these programs, they're a movable feast or moving target right now. To be fair, I think government generally has been, both provincially and federally and municipally, have been working way faster than they normally do. So that's certainly, nothing's been perfect, but I think they've recognized they need to support both business and individuals. I think the changes that are coming, and they are, they've already said they're going to do something different on the wage subsidy program. They recognize some of the deficiencies in that. And on the rent program, I was just saying this morning, I read in the newspaper when we all heard that the rent relief program was dead, that the minister is now musing about how to replace that. So there is things coming, but there's not enough information right now for you to comment on, or for us to even share what the programs look like. But that's coming in the coming days. So then it leaves us to pivot to some other things which are really important to our small and medium-sized businesses in particular. And I've gotten this question a lot through the things. What happens? What are my responsibilities if I have an employee have a positive test? Do I have to shut down? There's some on the business operations. The other one that is clearly an issue for everyone is what's an employer's responsibility to advise co-workers? Because then you get into, I don't know whether there's privacy issues, but that's one that I kind of get, is what happens in that scenario, both on the business operations responsibility side and then the responsibility to your other employees and your customers.
Yeah, well, to start with, in terms of if there's a positive test in the workplace, initially there was a lot of what looks in retrospect to be overreaction. So one person would have COVID that worked in a certain part of an operation, and the entire operation would be shut down and sanitized within an inch of its existence. And we've certainly got away from that, and I think we've properly gotten away from that. The way, and this comes with the science and learning more about how the virus transmits. Most of the time, what we're advising is to do your own sort of internal contact tracing, so to speak, in terms of who was working near that individual, who had a prolonged exposure to that individual, what was the nature of the interaction with that individual. But the fact that you have two people on the same floor, or two people in the same general space, but not actually near one another, there's no need to shut down the operations or bring in sanitizing groups to do that. Obviously, if that's what you feel is required to make you feel appropriately safe in operating the business and to make coworkers feel safe, then that may be what you need to do, but I don't think that's a requirement. In terms of advising coworkers of a positive test, most of the advice that we were giving for the last few months until the last couple of weeks was leave that to public health. Public health knows how to do contact tracing. They know who to, what the definition of prolonged exposure is, etc. And they should be the ones who are doing the contacting. Now, practically speaking, if someone all of a sudden isn't showing up at work anymore, you're going to have to communicate something. But what we are finding in the last couple of weeks, because of the surge in testing and the surge in cases and the delays in getting results, you can't wait. And that is very, for those of us who were relying on public health to do that work, it's disappointing recognizing that, everybody seemed to know that there was going to be a second wave or a surge, and yet here we are in the middle of it, and we don't have the facilities and the systems in place to do that contact tracing in a timely manner. And so during this delay, it would be unsafe, in my opinion, to not be communicating to people to say, we need you to understand that this individual has a presumptive case or is experiencing symptoms or has tested positive, whatever the right advice is. And from that perspective, public safety trumps that privacy right, or that, discreet kind of communication. There may be cases where that's not required, but from my perspective, we cannot go a week in our workplace knowing that someone has symptoms or has tested positive without communicating to our coworkers. We have a duty to take all steps reasonable in the circumstances to ensure the safety of workers. I think that would be or runs the risk of being found to have fallen short of that requirement to allow public health a week to get the results and start the contact tracing process. And so what I would say is you need to be judicious in the circle of notification. We don't need to send out an email. We don't need to post. We don't need to, publicly, shame is the wrong word, but to publicize that an individual has contracted or may have contracted the disease. So it's not everyone on the floor or in the facility. It's only those, in my view, with prolonged exposure or worked in close proximity for an extended period of time that ought to be notified. Those people ought to be told, and they ought to be told that they are not to, then broadcast that information widely. We're trying to lessen the stigma. Let's remember, these people are sick. It's an illness. We don't blame people for being ill. Now, even if they have made choices which make them may have made them more susceptible, this is an illness. And so from that perspective, we need to show that level of respect to our coworkers. And I think many employers will be judged on how they manage these kinds of issues. And there will always be those that will criticize, no matter what steps an employer takes in that circumstance. But from my perspective, I think that's sort of, you've got to find that appropriate middle ground.
The little bubble that was going on my head as you were saying that was, we shouldn't blame those that get sick, and it was Donald Trump was in there, ? But I'll leave that for the time being. But I think the important part of what I took away from that is being judicious. But public health trumps the privacy piece. That there's a, sorry, my other phone is going here. That's it. But public health is it does trump the privacy issue of the individual. And
yeah,
well, I mean, not exclusively, but I think that you have to notify the people. I think that's what you said. The people that need to be notified need to be notified.
Yeah, well, it's a health and safety issue. I mean, every employer has health and safety responsibilities under the OHSA. And so from that perspective, it is, we felt it reasonable when the turnaround time on a test and the contact tracing was 24 to 48 hours. We now know it to be a week or more. My daughter got tested a week and a half ago. It took a week to get those results. Well, in the meantime, is she supposed to keep working, not keep working? Those debates are going on in our house. And so that kind of timeline is too long. And so while I would like to, allow public health to do that work, practically speaking, and from a legal perspective in terms of health and safety, I don't think that's the right call.
So one of the things that as part of this testing, and I think there's a full court press by the province, by everybody, to make sure that there's more accessible, faster testing available, that you can get that turnaround, so you don't have kids staying at home from school or individuals staying home when they actually don't need to. One of the things that has come out, and I guess I'm interested in your view. I'm encouraging everyone to download the COVID app that is available that goes on your phone. What is that government contact tracing app worthwhile from an employer's perspective to try and encourage? You can't force people to put it on their personal phone. I know it took me about 15 seconds to download and put on there. It tells me, I don't know, every few days whether I've been potentially in proximity to someone that's had a case. What's your view of that COVID app?
Yeah. Well, when you've touched on sort of the key from a legal perspective. I mean, my own view on whether it's good or not is no different or no more important than anyone else on this call. But in terms of from a legal perspective, an employer cannot force employees to download and use that app. That's sort of the bottom line. And the way that the app was designed limits the privacy violation issues. I mean, we have folks in our firm who are very smart, very knowledgeable, have looked at a whole bunch of different kinds of contact tracing apps, and we've advised on many of them, both to employers but also to government or quasi-government entities. And this one is well designed from an expertise point of view. And I can tell you, our firm has encouraged all the members in our firm to use it. Mm-hmm. And if you can get some lawyers to endorse anything, it must be pretty well designed, because there's a lot of contrarians in that group. And so from that perspective, however, under the privacy legislation, and I know it sounds a little bit inconsistent with what we talked about a few minutes ago, but this is the privacy considerations outweigh the requirement of an employer or the desire of an employer to enhance the contact tracing exercise. So the conclusion that the governments came to, the federal government and others, is that under current privacy legislation, they cannot mandate it. They can recommend it. They've designed it in a way that is sensitive to the privacy issues. And exactly how that works, I don't know, but I do know it doesn't use GPS, it doesn't store the information, it doesn't identify who the person is, etc. But if you want more details, there's certainly folks in our firm who can provide them, but there's no need or no entitlement of an employer to sort of mandate that.
And that's important to know. On the other hand, certainly our chamber, the Cambridge Chamber, our Best Waterloo, which is a business economic support team, we are actively encouraging people to promote that and for individuals to do it. I mean, it's part of like the mask mandate, the way we protect ourselves and protect our friends and family is things like this, because it's in the absence of a vaccine, it's pretty important. So that's my editorial comment, not yours. It's not legal advice, but I just want to encourage folks to take just a little moment here. If you've got questions and you're on the line, I know I've seen a couple of comments. Yes, we'll be making sure that the recording is available on the website, because we're getting some good comments. Chris, you're doing a great job. There's some good information here, I'm told, but it'll be made available. But if you go to the chat box and have a question, put it on there. I'll be taking a look at that and trying to weave them into the discussion that Chris and I are having. So let's move on, and I think this is one, when we talk about rights, but what are the rights of the employees, and the employer when an employee refuses to work? And I guess there's different scenarios with that. Let me start with the one, and this, I hope this doesn't get into the tax side, but there were circumstances in the up to recently where employees were laid off, for lack of a better term, on SERB. Business starts to get back on its feet and wants people to come back to work, but the employee decides they're better off on the government program versus going back to work. That's one scenario. Maybe if I'd like you to comment on that, and then I've got a couple of other examples of scenarios that I think are very timely and businesses are dealing with right now.
Yeah, the SERB was from many employers' perspective, and we act for retailers, we act for manufacturers, where the wage rates in some cases are at or near the minimum wage, or the hours are, most of the employees are part-time and so aren't getting full weeks, the SERB was too lucrative for many of them. And so they were refusing to return to work. And in fact, in the early days, we had clients who were telling us, we are going to continue to pay our employees, in some cases, the average of the number of hours that they were working in the, prior to COVID, we're going to continue to pay them that many hours post the shutdown or the slowdown. And the employees were refusing the money. And they were refusing the money because if they accepted that money, they were disentitled to the SERB, and then they adjusted the SERB to allow for a certain amount of earnings. And so it was and at the time, I think we can criticize, but when you're making rules in a foxhole, which is really what was happening to the federal government at the time, they're not all going to be perfectly designed. They addressed some of those issues as things went along, so they allowed a little amount of earnings. Eventually, it was very clear that if the employer was offering you employment and you declined it, you were not supposed to be entitled to SERB. The challenge was there really wasn't a lot of follow-up on the entitlement to SERB. There wasn't a lot of questioning. And so there wasn't a lot of folks who were understanding that they needed to actually comply with that obligation. So, but luckily, I think we've now passed the SERB, the EI and the transition. We will start to have more scrutiny of whether those employees have available work to them and whether they're entitled to continued benefits. We are, and there was an article this past weekend or week in the Globe and Mail that was talking about we're now going to have a bit of a social experiment where there's two systems running parallel. There's the old EI system, and then there's the new CRB system. And in some cases, you'll be able to keep more as an employee of the amounts that you earn. You can keep more of your EI benefit or CRB benefit despite having earnings up to a certain level. And so we're going to find out how motivated people are to earn both, or whether they're content to just stay and receiving benefits. So, but from an employer perspective, again, going back to my earlier comments, I think what we do is we don't stand in the way of people's entitlements, but we ought not to be working hard to facilitate those things. Your more general question around work refusals, it really depends on the circumstance. It really depends why it is that they're refusing to work.
So here's one. If someone has I guess this is the legal point. If someone says they are worried about working because of the possibility of contracting COVID, which I think is it's a reasonable worry, but how do you balance that with the needs of the employer and the community, I guess?
Yeah, well, and that's something obviously that has been expressed by lots of employees, and it's been sort of from the first days when the essential workplaces were identified and people were required to continue to come into work as part of those essential businesses. So the starting point for any discussion around work refusals is to say, we have to assume that you as the operator of the business are complying with all the health and safety requirements. If you're not doing those things as required, then the rest of the analysis doesn't matter anymore, because you cannot force an employee to return to an unsafe workplace. And so what we have to do as a starting point for the discussion is to say, we operate on the understanding that you are taking care of all of the health and safety issues, the physical distancing, the hand hygiene, all that sort of stuff is taken care of. So then we get to, okay, assuming that's taken care of, can somebody refuse to return because they're worried? And the answer is no. The answer is we do not have a right, or an employee does not have a right to stay away from work because they're worried about contracting. They have some anxiety about contracting. Now, similarly, I suppose they cannot avoid returning to work because they are worried about taking public transit to work. It's sort of for some folks goes hand in hand. They cannot refuse because they're worried about the conduct of their coworkers or the perceived conduct of their coworkers. So for example, they know that Sally or Jimmy or Anand or whoever isn't following the rules or isn't being appropriate when they're, coming and going or at home, or they overhear that they're, doing something that by the worried employee's perspective is not proper conduct. Those do not entitle an employee not to come to work.
But that's where other stuff kicks in, right? If you're allowing employees not to adhere to the public safety, to the guidelines and the public health guidelines like distancing and wearing a mask and others, that's where that's where the employee should be turning, to make sure that it in fact is a safe workplace.
Yeah, well, I think that's true. I mean, the challenge that you will have as an employer, and we've had this many times, is I see two people arriving at work in the car together. They do not live together. They carpool, neither of them wearing a mask. I don't want to go into the workplace because I'm worried that one of the two of them has contracted and is transferring it to the next person, and they're acting unsafely, and I don't want to go in.
Mm-hmm.
Those kinds of things happen.
Yeah.
Or they go
Yeah.
for lunch. They go on the break or they go on lunch. 4 guys pile into a truck and they go down to Tim Hortons, and then they come back, and then they all put their masks back on and go back inside the workplace as they're required to do, and then they physical distance in the workplace, but they haven't been physical distancing for the 30 minutes that they were gone to Tim Hortons in the same truck. And those behaviors are not something that we can't police people on their private time,
Yeah.
so to speak. If there's a reason to believe that they have contracted, they have symptoms, we have to screen, etc. All those things come into play. But generally speaking, there is no entitlement to say, I'm worried that so-and-so might have it, so I'm not coming to work. Now, I will stop there and just say that in Nova Scotia, it's kind of interesting. In Nova Scotia, there is actually a human rights, one of the listed grounds of human rights is an irrational fear of contracting a disease. And that entitles you to human rights protections. Thankfully, we don't have that here in Ontario, because from my perspective, if you have the word irrational in your legal definition, that is not a good law, but that's my opinion.
All right, let me go on to it. There's a couple other here which I think are I think any sort of caring, rational person would say that there is some legitimate issues around. So if a parent has to, or makes, I guess in some cases, makes the choice to have their child stay at home and do online schooling, and that could be a choice, but it also could be, follow on to that, an employee that lives with someone that's high risk, right? That has type 2 diabetes, or your elderly parents are living with you. Those are still very complicated for an employer, but they add the added element of you want to do the right thing, but you still got to run your business. I mean, how do those parenting and having to stay at home with your kid? I have one of them. Mine is staying at home, so I'm fortunate because I actually work at home. And then employees that have, as I say, folks that are in higher risk categories.
Yeah, and interestingly, each of those is a different analysis. The starting point, of course, is you're in an ongoing relationship with your employees, and you want to keep that relationship positive.
Mm-hmm.
So you have to, find a way to get along. And you do that every day when you're operating your business. Of course, there are rules and people need to adhere to the rules, but there are times where you need to be a little more flexible. And businesses have done, in most cases, nothing but be flexible in the last 6 or 7 months.
Yeah.
When we're dealing with I'll start with the first question, which is a child that's staying home, online schooling. That is specifically covered under the Employment Standards Act, an infectious disease emergency leave. And so it falls under the category, and there's a list of things, and every employer should have these saved as their sort of on their favorites in terms of a link to the Ministry of Labor's guidance on these kinds of issues, because the IDEL, or IDLE, has really been expanded. It was modified as school was approaching. They modified it further. And so caring for a child who cannot care for themselves is covered under the EIDL requirements. Now, what does that mean, cannot care for themselves? Well, obviously, a special needs child would fall into that category. There's actually an age limit, one that would generally be 12 years old. But of course, there are parents who think that their 14-year-old cannot care for themselves. And so it will become a bit of a balancing act there. But there is very specific guidance around that particular issue. If those employees have decided not to send their child to school and they're going to do online learning, they are covered under an EIDL. And there is no time limit on that EIDL. So it will last as long as, in theory, the pandemic lasts. The government will ultimately decide when that timeline will end, but that is where we currently are. To flip over to the situation where you've got, an immunocompromised spouse, or you've got older parents, or whatever that may be, that is more of a human rights issue based upon marital status. If it's your spouse or your spouse's parents, then it may be family status. If it's a child, it's a human rights issue. And I can tell you that the Human Rights Commission is advocating a broader definition. And in fact, the Ministry of Labor, under its EIDL provisions, have talked about, taking care of an aunt, which is not technically, family status or marital status, because it's supposed to be parent-child. But in any event, the Ministry of Labor has very good guidance on its website, and it suggests that an EIDL applies in both of those circumstances. So the child staying at home, as well as you're taking care of a vulnerable or providing care to a vulnerable family member. And that, I've had the situation where I get groceries for my elderly parents, and I drop them off and I make sure they're okay, or I take them to their appointments or whatever it may be. And I think the ministry's guidance is that would fall under the EIDL provisions.
I want to come back just for a second. There was a couple of questions in the chat box just around the mask mandate and the various provisions, and I'm hoping that between you and I, we can, as before we post this video, we'll get the provincial mandate as well as the Region of Waterloo's mask bylaw, so people can see how the two fit together, because I think that's pretty important moving forward for folks listening in here. So moving on, Chris, as you say, they were, my description of when the pandemic hit, the federal government in particular was trying to design programs or design a plane while it was taking off and still building it all at the same time. So there's been, it wasn't perfect by any stretch, but the idea was to try and keep as many people employed through the wage subsidy program and other programs so that businesses could have enough cash flow and supports to keep their employees connected to the business and have a job for when we get past this. But is there an obligation for that employer to, their employees or past employees that may have been laid off since March? Like when business may be starting to increase, you're wanting to bring people back. Are there still the same obligations to the employees that have been laid off in a business?
Well, the government recognized, and most of the folks on the call, again, provincially regulated, would be familiar with the temporary layoff provisions in the ESA. And what they essentially said was, if you temporarily lay off an employee and you do not continue the benefits or make some other payments to that employee for 13 weeks within a 20-week period, so you could put them off, bring them back, put them off, bring them back. If it totals 13 weeks in a 20-week period, it was deemed an automatic termination. And there was nothing that anybody needed to do. It just became a termination. Similarly, if you did continue the benefits or continue to make payments to the employee, then it was 35 weeks in a 52-week period. And so what happened was, it was not something that people were thinking about at the moment, but what happened was we got to that 13-week window in the summer, and the government jumped in the day before it expired and said, okay, we're going to extend that period out. And they extended it for about a month or so at that point, 6 weeks perhaps. And then recently, when that period ran out, they were a little wiser and a little more foresight and extended it to January the 2nd. So what it effectively did was it stopped the clock on that expiry of that 13 weeks or that 35 weeks. And it converted those temporary layoffs into a what's called a deemed idle. Now, let me pause there and just remind folks, this applies to non-unionized workplaces only. Unionized workplaces are supposed to bargain, you know, the outcomes of these things. So it is specific to non-unionized environments. But what effectively happened was the period was suspended. They were now entitled to an idle. And what that means is they have certain rights under that idle, one of which is reinstatement.
Mhm.
If the employer decides during that period that they cannot continue the employment for whatever reason, then the employer, so long as it is unrelated to the employee being on the leave of absence, can terminate. There will be a debate in the end about whether we laid them off because of COVID. We ultimately decided we couldn't continue the employment because of COVID. So does that constitute a violation of the reinstatement obligations? I think the answer should be no, speaking as employer counsel anyway. And we'll ultimately see. But the idea is an employer has that ability to breathe until January the 2nd, where they're not going to get a massive number of deemed terminations, the consequence of which is they owe the employees all of those ESA payments, which in some cases can be very, very substantial. One thing that needs to be sort of highlighted is it applies not only to an outright layoff where the person is not working, it also applies to shortened work days or reductions in pay. What the government has said is if you are reducing the number of hours that employee is working, for that period of time when they are not working, they are also deemed to be on an idle. And so it is protecting that relationship. We're sort of in suspended animation as we go along, and we'll see what happens in January the 2nd. I'm hopeful that sometime before January the 1st, the government will decide what it's going to do, because at this point it's done it the day before on both occasions. So hopefully we've got a little more foresight at this point. But the other thing is it has interceded to stop claims of constructive dismissal. Many of the folks on this call will be aware of what a constructive dismissal is, which is, to put it very simply, is a substantial change to a fundamental term of employment. Obviously, reducing the number of hours and the pay that you're paying to people would be a substantial change to a fundamental term. What the legislation says is that will not constitute a constructive dismissal. Now, the point that they make, though, is it will not constitute a constructive dismissal under the ESA. It doesn't expressly deal with the right to claim constructive dismissal at common law. And this call is too short to explain go into the details of the differences of those two things. But for most of the folks on this call, they may have received demand letters from counsel for employees who say, you've constructively dismissed my client, and despite the changes to the ESA, we still think you owe this person, months and months and months of pay. Those folks ought to get some good legal advice. Obviously, our firm can provide it, but there are others who can also provide it. And there's lots of arguments to be made around that issue. And so, I would encourage all the employers on this call to ensure that they get that advice around that issue, because it is very confusing. I'm not going to try and paint it any different.
Okay, we're running out of time, but there was one question that just came in on the chat box, so I'm going to read it up here if I can see it. And it's around drafting offers of employment. Are there more legal considerations that have to be included to protect both the employer and employee because of the pandemic? So is that something you do at the time of offering a job, or is that sort of in the employee handbook part?
No, I think it ought to be at the offering stage, and let me give you an example. many years ago, myself and my colleagues started inserting the right to lay off as a provision in the employment agreement. Many employers didn't adopt that approach because they felt that the Employment Standards Act created the right to lay off. There's a bunch of case law that says, no, there is no right to lay off. If you have the right to lay off, have created the right to lay off, then the Employment Standards Act manages that right and describes what you can and cannot do and sort of puts a fence around what those rights are, but it does not create the right to lay off. And so I'm not going to say that we were prescient in seeing a pandemic coming down the pipe. Thankfully, I hadn't thought of one of those, but those clauses certainly came in handy because we avoided all of that argument around you've laid off my employee client and therefore we want to make a claim and we want 24 months pay. It put a stop to those. Another kind of clause, and this may sound a little radical, but I've certainly used it many times, both at higher levels and at lower levels. More often, I would say at higher levels, where you have the right as an employer to scale back the compensation of employees. Now, usually that provision will say something to the effect of you can reduce the pay of this individual so long as it aligns with reductions to others who are in the same sort of category within the business. So if you're reducing it for one manager, you have to be reducing it for all of the managers. You can't cherry pick, for example. That's the kind of provision that we've inserted in certain agreements. But specific to a pandemic, those would be the two that would jump to mind, because those are the things that we have seen have really been destructive for businesses. Is we cannot lay off and we cannot reduce pay or reduce hours without getting shouted at by our employees and their counsel.
There's my phone again. I'll have to turn that off. Listen, we could go on. I'm sure there's lots more questions here, but I want to thank you, Chris, for taking the time, and you're always generous with your time, and Gowlings is a great partner of ours, but having you take time out of your schedule to share your thoughts and give some great advice to our attendees, our members, and the business community as a whole is very much appreciated. So thank you for joining us today.
My pleasure.
And that brings us to the end of today's session. Reminder that we will be this recording will be made available on our website, but also shared with all of you in attendance. I do would ask that you register for next week's and bring a friend along. We are doing the Business Success Series every week, every Wednesday at 1 p.m. And so there's lots of great information on a variety of topics that'll be important to business. So thank you to our title sponsor. We wouldn't be able to make any of our programs work without the generous support of our sponsors. Manulife is our title sponsor. The platinum sponsor for this series, the Immigration Partnership of Waterloo Region. This month's presenting sponsor is BDC. And again, once again, to today's speaker, Chris Andre of Gowlings. And finally, to all of you for joining us today. Our next Business Success Series is next Wednesday at 1 p.m. And join us as we hear from the Student Access Talent Program Manager, Allison Mitchell, as well as representatives from our educational partners at Conestoga College, Laurier, and U of W. A great way to connect and get students that are bright and have lots to offer to your small and medium-sized business to help you with different programs. We'll discuss those opportunities. We hope to see you then. Please share this series with your friends and colleagues, and do join us every Wednesday afternoon at for the next edition of the Greater Kitchener-Waterloo Chamber of Commerce Business Success Series, brought to you by Manulife. And because it's Wednesday, it's Business Success Series, and we'll see you next week. Thanks so much. Thanks, Chris.